Chief Justice, thank you very much for talking to us at Anchored in Law.
Well, thank you.
Yes.
Thank you for inviting me.
Can I start with this question? What about the state of the judiciary keeps you up at night?
Well, I'm concerned that we don't finalize cases as expeditiously as we should. It's an old problem. And ideally, most of the reasons why cases still linger as long as they do in our court system should have been addressed by now. It's disappointing that we haven't been able to overcome that problem. I am concerned that many South Africans don't have access to justice. Litigation is just too expensive for an average South African to participate more meaningfully in litigation. And it's beginning to look like justice is only accessible to those who are financially well-resourced, and it shouldn't be. I am concerned that we haven't been able to keep pace with the technological developments that comparable jurisdictions have embraced to inject more efficiency and effectiveness in the court system and to make life easy for everybody, including the practitioners of the law. I'm still concerned that we spend many days and nights writing judgments as judges only for the corporate sector to have free access to them, package them, and sell them back to us at no discount. I think it's state capture that is not recognized as state capture. We've been fighting to create our own platform from which our judgments could be properly packaged and made available for free to all judicial officers and maybe all other people who are interested in our judgments, rather than leave them as a commercial venture available to those who ought not to be exploiting them in the manner that they do.
So what do you think could be the judicial intervention to make that a reality? In other words,
Which of the many?
For judgments not to be packaged and sold back to the judiciary. I mean, there is a platform like Safli, for example.
Yeah, we don't control it, but you have Judah, you have Butterworths that package our judgment in such a manner as to make them attractive to the readers and sell them to everybody, including the judges. What we have done is, since 2012, I've made it my business to examine what it is that other jurisdictions do to make access to judgments easily accessible and to all who are interested in them. I went to Ghana. My colleagues have developed a system that is very cheap to run. I went to Qatar, same thing, Singapore, and I think Malaysia as well. The challenge has been the budget to develop the capacity to do what colleagues have done, because what our plan is to have judgments available in that manner, and to also have some of the critical books available in that fashion. Obviously, we'll have to pay something to access them like that, but legislation and rules as well. Have a platform from which they could be easily accessed. And for those of us who still believe in hard copies, to see how it could be done. I know, for instance, the High Court, where I was judge president, used to package its own decisions like that in collaboration with a lecturer from the local university. So it's not something so complicated that you need some private enterprise to achieve. It's an easy thing to do. As a matter of fact, even those who are packaging these law reports to sell them back to all of us who consume them use judges and use law practitioners to do that for them.
Yes.
Why can't we tap into that resource to achieve the same objective? The only difference being that no money will be made out of it.
For the benefit of the viewers of this conversation, could you give us an example of what it is that they've done in Ghana, for example? Are you saying that what they've done is to do what you used to do as the Judge President of the Northwest High Court?
What they have done is they have employed one or two people who know IT well, and there is an appeal court judge responsible for their judicial academy who is also involved in that project, because they see it as part and parcel of what the Judicial Academy, the equivalent of our South African Judicial Education Institute, should be doing. And they have hard copies, but they also have a site where they have placed their judgments. And everybody has free access to them, including even universities, including practitioners. They don't have to pay anything to access those law reports. And the same applies to Qatar. The same applies to Singapore. I'm not too sure whether you pay a little something or not, but a number of jurisdictions have done that quite successfully.
Now, you mentioned, a last question on this segment, you mentioned effectiveness of the courts. Can I take you back to a judgment of, I think it was earlier this year, certainly reported earlier this year. It's a judgment of Jacobs and others versus the state. There has been a criticism that the Constitutional Court, in failing to reach a decision in that court, you remember it was a case of I think it was a conviction of murder on the basis of a common purpose doctrine. And 5 of the judges, in an application for leave to appeal, refused leave to appeal, and 5 judges would have granted it and granted the appeal. And so it's a 5-5 split. And so there's no decision, and therefore the appellants had to go back to jail. Now, the criticism was that the failure of the Constitutional Court to reach a decision there as an apex court was tantamount to a failure of justice. Comment?
Well, I think it should matter who's leveling the criticism and how much they really understand about the practical application of the law, because sometimes we tend to elevate some opinions, some views to a much higher level than where they actually belong. For starters, it is permissible for 8 judges to sit. And whether or not justice is done is not a function of necessarily having a majority when we sit 8 or 10. It is a function of there being a decision.
But is there a decision? Sorry to interrupt you. Of course there is. Is there a decision when there is
50-50?
50-50.
There is.
What is the decision?
The decision is effectively that the decision of the court whose decision was appealed stands. How different is that from a situation where the decision of an SCA or any lower court is upheld? What is our notion of justice? Is it when a decision of a lower court is overturned, or is justice still achieved even if that decision is upheld? Now, where there is 50-50, justice is done in the sense that the decision of the lower court stands. That is the law. Whether it is the SCA, the full bench of the High Court, or any other decision, there is a decision that applies. There is a law that is to be followed, and that is that decision, that last decision that was not overturned.
All right. Thank you, Chief Justice. We'll hold it here for the first segment, and then we'll continue with the other question in the next segment.